Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. We do have everybody present, which means we have a quorum. Good morning to the members. Good morning to those of you joining us on Zoom, and good morning to those of the public who may be watching either on the legislature's website or on the legislature's YouTube page. Welcome to day 17 of the 81st session of the Nevada Legislature. Before we get started, just a few housekeeping matters. For anyone on the Zoom, could you please mute yourself if you're not speaking? That'll help with the audio feedback. For any of our presenters today, when you present or when you respond to a question, please remember to state your name for the record. That'll make our committee secretary's job a little bit easier when preparing the minutes. I'll try to remind you to do that if you forget, because I know it's not a natural thing to do in conversation. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly okay. That's why the legislature is here, to figure these things out. But we have to make sure we're being respectful to one another, to staff, and also to the legislative institution. And finally, members have multiple screens in front of them, most likely, trying to participate on Zoom and also look at exhibits. So please don't see it as a sign of disrespect or inattention if members appear to be looking away at other devices. We're probably just trying to get a grasp on what's going on in the meeting. With that behind us, we're going to move to our agenda. Members, as you can see, we have two bills on the agenda today. The good news is we have the same presenters for both of the bills. So at this time, I'm going to open the hearing on Assembly Bill 23. Assembly Bill 23 revises provisions regarding the procedure to commit an incompetent criminal defendant. And with us to present the bill today, we have Dr. Neighbors and Ms. Millay from the Division of Public and Behavioral Health of the Department of Health and Human Services. So I want to welcome you to the committee hearing. What we'll do is give you a chance to present the bill, then we'll take questions from the members before opening up for additional testimony. So when you're ready on Assembly Bill 23, the floor is yours.
So thank you, Chairman Yeager. Good morning, Chairman Yeager and members of the committee. For the record, my name is Elizabeth Neighbors, and I'm the statewide forensic director for the Division of Public and Behavioral Health. And we would like to thank you for giving us the opportunity this morning to present in support of AB 23. First, what I would like to do is to speak a little bit about what we're asking in the bill, and then talk some about the comprehensive risk assessment that this affects, and what is entailed in doing one of those risk assessments, and then sum up about why we are asking for an expansion of the time to present those comprehensive risk assessments to the court. So AB 23 proposes changes in the time frame for submitting the comprehensive risk assessment that's required when a petition is filed to commit an incompetent defendant under Nevada Revised Statute 178.461. And these are individuals whom we have had at the forensic facilities for restoration of competency to stand trial, and whom we have been unable to restore after considerable effort to competency. They are individuals who are charged with very serious crimes and who, for whom there's considerable doubt that they are appropriate for commitment to a civil hospital or for discharge to the community. Presently, when that occurs, when there is a petition filed, the evaluators at the facility are notified by the prosecutor, and there is a request that we complete a comprehensive risk assessment answering the question about whether the person is in need of the level of care and security of a forensic facility. And that commitment can be up to 10 years or more. At issue here is the fact that we have, when we are notified to complete that comprehensive risk assessment, we have about 7 days to assign an individual and gather the data and complete the assessment to provide to the court. The hearing is within 10 days. The risk assessment has to be there 3 days before. So that limits the time to the 7-day period. If we get the notice on a weekend, then obviously that shrinks the time frame even more. And so we have been working with this for a number of years now and found that it is very difficult, and frequently, probably almost uniformly, we have to ask for extensions in order to do this in an appropriate and responsible manner to deliver the recommendation that's appropriate to the court. Another issue that is involved in this is we have a somewhat limited pool of evaluators that are available to perform these evaluations. They need to be performed by doctors who are credentialed and trained to do this particular type of risk assessment. And so these doctors are also the same individuals who perform all of the competency to stand trial assessments for the state as well, north and south. They have many clinical duties. They do other evaluations, other types of risk assessments, mental health assessments, criminal responsibility assessments. They sit on treatment teams. They are officers of the day. They facilitate admissions and a myriad of other clinical duties. So when we receive a request to complete one of these risk assessments, that assessment has to be accommodated within the workload, caseload of the other duties that these evaluators have before them, which can be kind of daunting. We operate pretty much at full capacity at both of our forensic facilities, and certainly there's no shortage of work. So the goal that we have here is to balance all of this with a reasonable time frame to complete these evaluations. There are high stakes, as I said. These evaluations have an outcome that may result in an individual being committed for up to 10 years, which for certain offenses can be extended by 5-year increments to a forensic facility, which is a psychiatric hospital, and they receive appropriate treatment and care. But this is a significant intervention upon their personal liberty, certainly. And it weighed it too against the concern about if an adequate decision and evaluation has not been done, possibly releasing somebody to the community who is dangerous. And so certainly we have concern about protecting the community as well. So it is extremely important that these be done carefully and with deliberation. Another point in terms of the evaluators certainly need to invest a great deal of time and care with these is the fact that in all cases except murder and sexual assault, the recommendation of the evaluator is the court is obligated to find in concurrence with that recommendation. Should the evaluator recommend that the petition be denied and the person should not be committed to a forensic facility, the judge is obligated to dismiss the petition. So the evaluator really carries a very large burden of responsibility in completing these evaluations appropriately and needs adequate time to do that. So talking a little bit about the nature of the risk assessment, this is not just a checklist. It is an extremely time-consuming and labor-intensive collection of data, which includes records from external records from past hospitalizations, prisoner jail incarcerations, and collateral interviews with individuals who have known the person in order to complete the standardized risk assessments that we require in the protocol that's used to come to the conclusions that the evaluator presents to the court. This includes also internal records, as well as I mentioned all of these collateral interviews and extensive interview with the client themselves who are being evaluated. Recently, I was reviewing, peer review is also part of this, and so that adds to the time. These evaluations probably consume at least 30 to 40 hours of professional time by the time the data is collected, the tests are administered, and the report is produced. And they are extensive reports, 15 to 20 pages long. So there is a great deal of time invested in these. And as I was pointing out, that 7 days or less to try and complete this in the context of one's regular caseload is a very limited time frame. So that is why we are asking to expand this time frame in the statute. We have asked to have a reasonable time to complete the evaluation, and that the hearing that happens after the evaluation is completed to make the decision about the person's commitment would then be docketed within 10 judicial days of the time the report is received. We have been having some discussions about this. I don't know about the appropriateness of addressing this here, but we are aware of and sensitive to the concern about the possible subjectivity of the language reasonable time frame. Our interpretation of that would be an estimate of 30 judicial days, with the potential to extend that if it was necessary to, for example, collect more data than what we have available to us, or if we don't receive it in a timely manner. So that we would be open for that consideration. But we do feel that under the circumstances, it is really imperative that we have available to us a more expansive time frame in order to do these evaluations in an appropriate and professional manner. So with that, I will thank you for your time, and I'm happy to answer any questions.
Thank you for the presentation, Dr. Neighbors. We have some questions. I want to ask just a couple of questions to lay the groundwork. I think I understand this process, but I want to make sure I have it accurate. So, if someone is deemed to be incompetent to stand trial, then they are transported to the state forensic facility. And am I correct that the only facility in the state that does competency restoration is Lakes Crossing, which is up here in Sparks, Nevada?
No, actually, we opened a new facility in Las Vegas in 2015, late in 2015, which has been performing the same services that Lakes Crossing performs in the South. So we now have 2 facilities that operate and perform that function.
Great, thank you for that, Dr. Neighbors. And is that Stein Hospital in Las Vegas that you're referring to?
Yes, that's correct. I'm sorry, I should have said the name.
So then, just procedure-wise, if you look at Section 1 of the bill, obviously it indicates that if somebody is found to be essentially, here, let me find it. Well, Section 1 references 178.425, which basically indicates what happens if a defendant is deemed to be incompetent without probability of essentially becoming competent. And so my question is this: either that person is going to be in state custody, either at Lakes Crossing or at Stein Hospital in Las Vegas, if under 178.425, once the court receives notice that the person's incompetent without probability, that statute indicates that the court essentially has to dismiss the case. But then the statute as it exists today allows the district attorney to basically file a petition to say, wait a second, don't release this person. They could be dangerous. So I guess my question is, once the court orders dismissal of the case, that person is going to, the defendant is going to stay in custody for some period of time, because we have to wait and see if the district attorney is actually going to file that motion. Is that how it works in real life?
Yes, Elizabeth Neighbors for the record. Yes, we have, when a person is deemed incompetent without probability, the statute, I believe, reads that we have 10 days. There is a time frame that we are allowed to either, we get an order to civilly commit or release the person, unless there is the petition filed for the long-term commitment. So if the person doesn't qualify under the 461 section and they're incompetent without probability, then their charges would be dismissed, and we have a window in which we can petition, and the facility does that for civil commitment if we believe that they meet criteria for civil commitment. If they do not, then there are other discharge plans arranged, and they are discharged to services in the community. If this long-term petition is filed. Then the person remains with us while we complete that process, and the court makes a decision about whether they're going to be committed under 461.
Thank you. And I think the last question I have, and I'm not asking for specific numbers unless you have them in front of you, but when the situation happens when someone is incompetent without probability, how often do district attorneys file these type of petitions that are referenced in the bill? Does that happen a lot? Is it like half of the time? Do you have any kind of general sense of how often they file?
Yes, actually the numbers are not huge. Again, for the record, Elizabeth Neighbors, we have been getting about one petition a month, which may seem like a lot to us in the grand scheme of things, that those are not big numbers, but for an evaluator, that is one fairly large chunk out of their monthly schedule to complete one of these evaluations. So we have about 23 individuals committed statewide under this statute right now. And it began in 2007. And so obviously they accumulate. We are seeing probably more petitions. As I said, it's within the last year, we're beginning to have about one a month. Prior to that, we would have, and I'm just estimating, more like 3 or 4 a year. So the actual number of petitions has increased.
Thank you, Dr. Neighbors. And before I move on to other questions, obviously with COVID, options are limited, but I did have an opportunity to tour Lakes Crossing up here in Sparks back in, I think it was 2013. And so, you know, when they're back open and ready for visitation, either there or Stein, I would commend that to members if you're interested to just take a tour of the facility and see what's happening there. I think it helps inform the context of this bill, but, you know, obviously we can't do it right now, but hopefully soon we'll be able to. Dr. Neighbors, I have a few other questions at the moment, so we'll start with Assemblywoman Bilbray Axelrod, and then we'll go to Assemblywoman Cohen. So please go ahead, Assemblywoman Bilbray Axelrod.
Thank you very much, Chair. And I was actually looking at Lakes Crossing's website last night when I was reading the bill, and it doesn't mention Stein. It says that Clark County uses a private company, so might want to update that. But that's not my question. My question is, you mentioned earlier in your testimony that you often ask for additional time. Can you walk me through what the process in asking for additional time looks like, and how long do you typically ask for?
Certainly, yeah. Through you, Chairman Yeager, to Assemblywoman Bilbray. So it varies from venue to venue. Sometimes it's a relatively simple, just simply contacting the court. I guess one thing I might comment is we have a specialty competency court in Clark County, which really helps to facilitate and expedite matters. And so all of these proceedings in Clark County are carried out in that court. In the rest of the state, there's other 16 counties, these petitions would remain in the criminal court where the charges were originally filed. So we would have to ask each one individually. In Clark County, it's a little easier, so we simply contact the competency court and the court approves the extension. We have generally been asking to extend the 7 days up to 30 judicial days. I don't recall a time that hasn't been granted, but it means that we have to go back and request. In other courts, they have requested that a hearing occur in order to grant the extension. So that does include, when we have to do that, an additional hearing with all of the process that goes along with that and expense. So generally, it's about 30 days. Sometimes it's been more depending on the situation, how complicated the case is, but I would say rarely more than 30 days.
Thank you for that. And just a small follow-up, if I may, Chair.
Please go ahead.
Thank you. So that makes sense. So you're at, and you use the term 30 judicial days. So I believe you're familiar with the amendment offered by the PDs. And I think a lot of the committee, when we saw the term reasonable, I think that we all kind of were a little taken aback because, you know, the definition of reasonable can be very different for different people. Like my daughter, in fact, has a very different definition of reasonable than I do. So other than, are we just a stickler on judicial or calendar days with the amendment? Is that correct?
Yes, and for some very particular reasons. So I actually was counting up the number of days if it's chronological days. The number of work days that fall out in varying windows are considerable. We also have furloughs right now. So we have people who cannot work on their furlough days and are limited. Some of this staff that do this are part-time staff, and so they can't do additional work. Sometimes they help us out by doing paid additional regular time to complete these, but they cannot do that in a week in which they have a furlough. And then, of course, holidays. So it helps if they are judicial days to give us an absolute amount of hours of actual work hours that we have available to complete this, as opposed to a chronological calendar.
Thank you very much.
Thank you, Dr. Neighbors. And let me just ask a quick follow-up to that while it's on my mind. I think it's probably pertinent to the question that was asked. So I certainly understand that you need time to do the report. I guess my question would be, if you can make any conclusions when you're doing these reports, how long on a typical basis has the defendant already been in state custody, either at Stein or at Lakes Crossing? Are we talking months? Or are we talking years? Can you give us any kind of conclusion? I think that'll sort of help us process what might be the appropriate time frame for the report.
Certainly, Elizabeth Neighbors for the record. There are serious crimes, and so there's a tendency for those folks to have certainly an investment in restoration, maybe longer than under lesser offenses. I actually can think of two of these at least where they were not in Lakes Crossing at all, and there was a very expedited process that had this petition filed and then a subsequent effort at conditional release. So that gave us very little past record for us to review. Most of the time, I would say for all of the ones that are here right now, that the time frame is between 6 months to 2 years that they're here for and with an effort at restoration before the decision is made to say that they can't be restored.
Thank you, Dr. Neighbors. That helps. We'll go next to Assemblywoman Cohen, and then Assemblywoman Kasama.
Thank you, Chair, and thank you for the presentation. I have a question about the hearings that are referenced in the bill. I think you already answered one, that when you file a request for an extension, that's sometimes the court asks you to come in for an actual hearing in the court. But in Section 1, Sub 5 and Sub 7, B, there's also other hearings that are addressed. Are those hearings court hearings, or are those done in chambers, just based on the pleadings?
Okay, I'm aware of other hearings. I'm looking here.
Sorry, it's so Section 1, Sub 5 is the first one. That's the eligibility of defendant for conditional release once every 12 months.
Oh, yes. Those are the annual hearings that are required in 178.463, 61 through 63. The person, once they are committed under 461 for up to 10 years, the individual has the ability to petition once a year for conditional release. We are also required to do an annual report in which the question is the person eligible for conditional release? Have they improved and recovered to the extent that they could be safe in the community on a conditional release program? The division can do that at any time. The individual only can do it once per year. And then there is that required annual hearing at which that is considered in the original, either the competency court in Clark County or the original criminal court of the charge.
Okay, that's an actual hearing in an open a hearing in court with the person having counsel and that type of thing, not an in-chambers hearing.
Yes.
Okay, thank you.
Okay, let's go to Assemblywoman Kasama, please.
Thank you, Chair. Assemblywoman Heidi Kasama for the record. I certainly, based on your presentation, certainly understand and see the need for you to have more time for the comprehensive risk assessment. And in the changes here, it just has in a reasonable period, which you've talked about. Would is it typically, I think you were saying you could get it done in 32 days or 60 days. I'm just wondering if there should be, instead of a minimum time, that if we were to have a cap on the time within a reasonable period of not more than 60 days or 90 days or 120 days. I'm just wondering if there's a time frame that you feel comfortable with that could always be met to get the risk assessment done.
Through you, Chairman Yeager, to Assemblywoman Kasama. These individuals are each unique.
Mm-hmm.
And to set an absolute maximum time frame, I guess in part I would say it depends on what it is. 120 days would be a lot. Probably 60 days would work. I would be a little hesitant to make the cap the absolute 30-day cap in case there was some unforeseen, event or issue that arose that made it extremely difficult to do that, and we couldn't ask for an extension.
I can certainly sense your hesitation that you just want the flexibility, and I guess so long as the process is moving along, so that comprehensive risk assessment, for some reason somebody wouldn't linger for 3 years. I mean, I'm sure you have the process and you move it forward. I guess that was the thought I had in my mind.
Well, and I would agree with that, and we are sensitive to the person's constitutional rights not to be held longer than is appropriate in a more restrictive setting without the appropriate due process. And I actually have to kind of do kudos for the staff. I've recently had at least 2 occasions where the person got it done sooner than the extension, which we had asked for. So there is a considerable effort to meet those needs and parameters of the.
Okay, well, I certainly agree with the flexibility. You don't want to be hampered by that, so you can do a good job, but just curious about that. But thank you for your response and your overview.
Thank you for the question.
We'll go next to Assemblywoman Summers Armstrong.
Thank you, Chair Yeager, and thank you, Dr. Neighbors, for your presentation. I have 2 questions, just for clarity. When you request an extension, is it generally for 30 days?
Through Chairman Yeager to Assemblywoman Summers Johnson, yes, that is a typical time frame that we have found it comfortable for us to work within in order to complete these.
Okay, thank you for that. And my follow-up question would be, when does therapy for those who are in your care begin? During this assessment program, while you are doing your background, do you begin any assessment to get them along their way, or are they just held in stasis during the time that you are conducting your review?
For the record, Elizabeth Neighbors, the therapy begins in essence when they arrive at our facility. We have a very comprehensive program to restore individuals, which addresses their psychiatric needs as well as their medical needs within, although we do have medical clearance because there's some things that as a psychiatric hospital we cannot address. Our focus, because we are working to restore individuals to competency, is very focused on that goal. And we have regular classes in legal process. We have 4 treatment teams that the clients are assigned to. They have a sponsor who is a forensic specialist who is their daily go-to person, plus a psychologist, psychiatrist, nursing staff, and a very active and comprehensive recreational therapy program, which is very important with this population in helping them to recover from their various mental health diagnoses and issues that they may bring when they come to the facility, so that they can focus on their criminal case and become competent and move forward and resolve their legal entanglements. The program is a little bit different for individuals who are committed long-term. And in that case, the goal is obviously not to go back to court, but to to recover to the point that they can be in the community and function, and hopefully eventually be discharged from our supervision. And so it is a comprehensive milieu therapy, recreational therapy, psychiatric and psychological interventions, and very comprehensive program of daily living that we provide for them.
Thank you. Chair, if I may ask one follow-up. Thank you. Is this facility strictly for criminal commitment, or is it open to the public or other? Is it a strictly for your purposes, or do other folks use that facility as well? The Stein facility in Las Vegas.
Through you, Chairman Yeager, to Assemblywoman These facilities are we strictly receive individuals who are ordered to the facility by the court. So even the long-term clients who stay here and after their charges are dismissed without prejudice, they have the path into a forensic facility is always through the courts. There is a provision if there is someone who's in a civil hospital who is not, the civil hospital is not able to appropriately manage them because of, say, violent behavior, they can be administratively transferred to us for treatment until they are appropriate to return to the former setting. That is a pretty rare occurrence, but there is that provision in the statute for us to do that.
Thank you very much.
Okay, do we have further questions from committee members? If you could raise your hand in front of your camera, and if you have a question, I will call on you. Okay, I don't see additional questions at this time. Dr. Neighbors, I want to thank you for presenting. Obviously, I'll ask you to stick around to do any follow-up or any concluding remarks after we take a testimony on the bill. So at this time, I'm going to go to testimony in support of the bill. I don't believe we have anybody on the Zoom who will be testifying in support, but if I'm wrong about that, just turn your camera on and let me know. Okay, I don't see anyone on Zoom, so BPS, if we could go to the phone line, please, and check to see if there's anybody who'd like to testify in support of Assembly Bill 23.
Good morning. Thank you, Chair. For callers wishing to testify in support, please press *9 now to take your place in the queue. Callers wishing to testify in support, please press *9 now to take your place in the queue. And Chair, the public line is open and working. There are no callers in support at this time.
Thank you, BPS. I will close testimony in support. I will now open testimony in opposition to Assembly Bill 23. We don't have anyone on the Zoom in opposition. BPS, can we check to see if there's anyone on the phone who would like to testify in opposition to Assembly Bill 23?
Thank you. For callers wishing to testify in opposition, please press *9 now to take your place in the queue. Callers wishing to testify in opposition, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 611. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chairman and members of the committee. This is John Piro, John-Piro, representing the Clark County Public Defender's Office. Per the rules of the committee, because our proposed amendment is unfriendly, we are currently in the opposition position. We agree with Dr. Neighbors that the previous deadline of 7 days was far too short, and frankly, we always ask too much of our state workers who bear the brunt of a lot of the things in this state without a lot of support. We agree with Dr. Neighbors that we're not trying to release dangerous folks into the community without a full evaluation. However, we were originally opposed to the reasonable language. Reasonable as a legal term has been around since 1835. It's a legal fiction, and it has provided numerous arguments between courts, lawyers, and parties since 1835. So we are glad that they had taken some of our suggestions to put a 30-day cap on it. However, we are still in talks about judicial days or 30 calendar days. We believe that our amendment, 30 calendar days, with the ability to ask for extensions if needed, provides a little bit more certainty to both the courts, the person awaiting evaluation, the person doing the evaluation, as well as the public. But to be clear, we don't want this bill to die. We just think our version is better, and we thank Dr. Neighbors and the staff working on this bill for discussing it with us at this time. And that concludes my testimony.
Thank you for your testimony, Mr. Pirro. BPS, could we go to the next caller in opposition, please?
Yes. We will take the caller with the last three digits of 318. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary. This is Kendra Birchie, KendraBertschy, and I am the lobbyist for the Washoe County Public Defender's Office. First, I want to thank Dr. Neighbor as well as the other sponsors of this bill for spending so much time speaking with Mr. Pirro and myself to go over our concerns. Our main concern, as Mr. Pirro indicated, is the issue of the language for reasonable. Reasonable is a slippery standard, especially when there's a chance that a community member can be released safely. Specific dates are necessary to monitor the case to ensure that the proceeding continues and does not get lost in the system. We agree that 7 days is not enough time for the division to complete this very important comprehensive risk assessment after someone has been found to be incompetent and not likely able to regain competency. We believe that the 30 days, and that would be calendar days, is necessary in order to balance the constitutional rights that our clients have, as well as with the safety concerns and the necessity to ensure that the risk assessment is done completely. I would just note that the rules of, in essence, what we're dealing with is almost a quasi-civil issue, because at this point, the legal criminal case is going to be dismissed. The concern is just if that person is to remain at Lakes Crossing or Stein, or if they can be safely released into our community. So I believe that it's important to look at the rules of civil procedure that discuss computing and extending time. In 2019, this was adopted the state Nevada adopted the federal time computation standard, which includes calendar days. So that's one of the reasons why we wanted to request calendar days, to ensure that there are very specific time frames so that everyone, all the parties, the victim, if there is one, the defendant, everyone knows what the next step in the process is going to be like. And with that, I appreciate that Dr. Neighbors is still willing to speak with us in order to figure out how we can come to an agreement in order to ensure that all individuals are handled in the same manner in terms of that there is a definite time for their next hearing, that they're fully aware of what that is, and that it also balances the safety interests. Thank you so much for your time today.
Thank you for your testimony, Ms. Birchie. BPS, do we have anybody else on the line in opposition?
Caller with the last three digits of 037. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, spelled Tonjabrawn. Tanya Brown, Advocates for the Inmates and the Innocent. I concur with Spurkett and Mr. Pirro that we are in opposition. Thank you and have a good day. Thanks. See you. Go away. Bye-bye.
Thank you for your testimony, Ms. Brown. BPS, anyone else in opposition?
We are currently in opposition for the bill. If you have recently joined the call and would like to testify in opposition, please press *9 now to take your place in the queue. Callers wishing to provide opposition, please press star 9 now to take your place in the queue. And Chair, there are no further callers for opposition.
Thank you. I will now close opposition testimony. At this time, I will open testimony in the neutral position. BPS, can we check to see if there's anyone on the line who'd like to testify neutral on Assembly Bill 23?
Yes, thank you. For callers wishing to testify in neutral, please press star 9 now to take your place in the queue. We will begin with caller with the last 3 digits of 048. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Mr. Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen as in the Assemblywoman, but no known relation that we're aware of. So I want to highlight the story of Matthew Rushin, R-U-S-H-I-N, from Virginia as an example of why mental health concerns should be decriminalized before folks sometimes unfairly enter the criminal justice system. So in broad strokes, with the time that I have, Mr. Rushin was sentenced for a car crash. Ultimately, once his mental health concerns were noted, he received a conditional pardon from the governor of Virginia. Unfortunately, because of COVID restrictions, etc., despite that conditional pardon, he has not yet been, to the best of my knowledge, released from the correctional facility. Unfortunately, as the press found it relevant, he caught COVID in the process. So in sum, I think we should kind of take a broad strokes look at the mental health system in intersection with criminal justice. And I'm happy to work with the agency and the committee on language that's reflective of that. With that, Mr. Chairman, thank you, and I yield.
Thank you for your testimony, Mr. Cohen. BPS, is there anybody else who'd like to give testimony in the neutral position?
Any further callers wishing to testify in neutral, please press star 9 now to take your place in the queue. Callers wishing to testify in neutral, please press star 9 now. And Chair, there are no callers to testify in neutral at this time.
Thank you. I will close neutral testimony. Dr. Neighbors, would you like to give any concluding remarks on Assembly Bill 23?
Thank you, Chairman Yeager. I'd just like to say that I appreciate that the Public Defender's Office North and South has been very open to talking with us, and I assume we will have some more conversation about this. And so we are looking at their concerns certainly as well.
Great. Thank you, Dr. Neighbors. And please just keep me updated on the progress of those conversations. Certainly, we would appreciate it if you're able to come to some kind of agreement. But if you're not, that's what we're here for, and we'll make the best decision we think that makes sense for the state. But if you could keep us updated on how that's going, we would appreciate it.
We will certainly do that.
And at this time, I'm going to close the hearing on Assembly Bill 23. We're now going to move to our second bill on the agenda. I will open the hearing on Assembly Bill 24. Assembly Bill 24 revises provisions relating to a forensic facility to which certain offenders and defendants with a mental illness may be committed. Welcome back to the committee. Dr. Neighbors, like we did with the last bill, we'll give you a chance to present. We'll have some questions and then we'll take testimony. So please go ahead when you're ready.
Okay, thank you very much, Chairman Yeager. Elizabeth Neighbors. I don't think I spelled my name last time, so it's Elizabeth. Neighbors, capital NEIGHBORS. So Assembly Bill 25, I believe, is very straightforward. What we're really asking for here is to update the definition of a forensic facility in Nevada Revised Statute 175.539. And this does, in an indirect way, kind of connect to the last bill, because we have to have a definition for a forensic facility in the comprehensive risk assessments that we do. And we are finding that it is, we have more statutes that refer, for example, about where people go, and we need to be clear about what facilities constitute a forensic facility. There have been some changes. It used to be, as you noted, that Lakes Crossing was the only forensic facility in the state. That is no longer true. The statute does refer without limitation to Lakes Crossing, and we would like to add Stein Forensic Facility, which is part of the SNAM's facility in the south, to that definition. And the additional language in the bill that we are asking to add indicates that the Division of Public and Behavioral Health going forward can designate which units or facilities they oversee would qualify as a forensic facility. In the process of making those changes, we also would, that's not, I don't know how relevant that is here, but we have discussed that we would also do policy that would detail more clearly the exact attributes and requirements of a forensic facility. So those are the changes that we are asking for in AB 25. And as I said, I think it's pretty straightforward. So I'm happy to answer any questions about that.
Thank you, Dr. Neighbors. And just so the record is clear, you mentioned SNAMS, which I believe is Southern Nevada Adult Mental Health Services. Did I get the acronym right?
That's correct. I'm sorry. I'm so used to using the acronym and not saying the whole name.
Well,
but
and
that's correct.
And for good reason. I mean, it's a very long name, but that'll help our committee secretary prepare the minutes. So I understand your presentation. I guess just one sort of summary question. I mean, really the change here is just intended to give the division flexibility as additional facilities come online. We could get more in the future. This definition just gives you a little bit more flexibility of where you can place people when they need to be placed in a forensic facility.
Yes, that's correct. And over the last decade, we've doubled the number of beds in the state. And so we anticipate that going forward, that expansion is probably not going to change. And we've retrofitted a couple of units that were civil facilities. And so it's helpful to be clear that those are what is defined in the statute.
Great, thank you. Thank you, Dr. Neighbors. Any questions from committee members for Dr. Neighbors on Assembly Bill 24? If you have a question, if you could raise your hand so I can see it in front of the screen. And yeah, I will note for the record, I think Dr. Neighbors, a couple times you said Assembly Bill 25. Of course, you meant Assembly Bill.
Sorry.
It's okay. I think that's on tomorrow's agenda. So of course you meant Assembly Bill 24. So I'll just ask our committee secretary to make that correction to your testimony to make sure the notes are clear. The minutes are clear that we're talking about Assembly Bill 24.
I apologize. I've been looking at all of them.
And this is a consequence of having all your bills on consecutive number order. So it's easy to confuse them. No problem at all. Committee members, any questions for Dr. Neighbors? Okay, I don't see any questions at this time. So let's go ahead at this point and open up for testimony in support. We don't have anyone on the Zoom in support. BPS, could we check to see if there's anybody on the phone who would like to testify in support of Assembly Bill 24?
Thank you, Chair. For callers wishing to testify in support of Assembly Bill 24, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 611. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning again, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Piro, JOHNPIRO, from the Clark County Public Defender's Office, and we are testifying in support of this bill. And we thank Dr. Neighbors for bringing it forward to kind of modernize our statutes and recognize that we may even have more facilities in the future, and that we've had a facility that hasn't been recognized in the statute since 2015. So we are grateful for her bringing this legislation forward to start to update our statutes. And that concludes my testimony.
Thank you, Mr. Piro. BPS, do we have anybody else on the phone in support of Assembly Bill 24?
Any further callers wishing to testify in support, please press star 9 now to take your place in the queue. And Chair, there are no more callers in support at this time.
Thank you. We will close testimony in support. I will now open up testimony in opposition. We don't have anyone on the Zoom with us in opposition. BPS, could we check the phone lines to see if there's anybody there who'd like to testify in opposition?
Thank you, Chair. For callers wishing to testify in opposition, please press star 9 now to take your place in the queue. For callers wishing to testify in opposition, please press star 9 now to take your place in the queue. And Chair, we currently do not have any callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now open neutral testimony. BPS, could we check to see if we have anyone who'd like to offer neutral testimony on the phone line?
Thank you. Callers wishing to testify in neutral, please press star 9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 048. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Mr. Chairman, members of the committee. Stephen Cohen again for the record, previously identified. I'll keep it nice and short and sweet. Ditto my remarks previously entered as to Assembly Bill 23. With that, Mr. Chairman, thank you and I yield.
Thank you for your testimony, Mr. Cohen. BPS, anybody else on the line in the neutral position?
Any further callers wishing to testify in neutral, please press star 9 now to take your place in the queue. Callers wishing to testify in neutral, please press star 9 now. And Chair, the public line is open and working. However, there are no callers for neutral at this time.
Thank you, BPS. I will close neutral testimony. Dr. Neighbors, any concluding remarks on Assembly Bill 24?
No, I just would like to thank again for the support on that bill, and I think it would be very helpful in our process going forward.
Thank you, Dr. Neighbors, and thank you for joining us here this morning to present these bills. And I believe we're going to see you tomorrow morning for a couple more bills, and we'll look forward to that. So until then, have yourself a great day.
Thank you very much. You too, as well as the members. Thank you.
So I'll close the hearing on Assembly Bill 24. And that committee was our simple bill, unlike the bill I described last week, where we had all kinds of technical difficulties. So sometimes it works out the way you think it's going to work out. We're going to now move on to public comment. As a reminder, we will take up to 30 minutes of public comment. Callers on the public comment line will have 2 minutes to provide their public comment. BPS, could we go to the public comment line? And if there is somebody there wishing to testify, could we get them set up and have them provide their testimony, please?
Thank you, Chair. Caller with the last 3 digits of 0611. My apologies, Chair, that person hung up. We will go to caller with the last 3 digits of 048. Caller with the last 3 digits of 048. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
BPS, so I've already concluded my remarks, so I don't know if there's a way to, should I drop off or how would that work?
Is this Mr. Cohen on the line?
Correct, Mr. Chairman.
Okay, Mr. Cohen, did you want to give any other public comment? Or I think you said you didn't, but I just want to confirm whether you wanted to give public comment at this time.
Correct. I'll be submitting more for thorough remarks to the committee manager.
Okay, great. Thank you so much, Mr. Cohen. We appreciate that.
No problem.
BPS, do we have anybody else on the public comment line who'd like to provide testimony?
Caller with the last 3 digits of 556. And again, caller hung up. Let's try caller with the last 3 digits of 363. Caller with the last 3 digits of 363, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Daniel Purdy, for the record, P-U-R-D-Y. Daniel Purdy, brother of Thomas Purdy, murdered at Washoe County Jail. I was out there about a year ago. I was surrounded with my 12-year-old son by 6 deputies, none wearing body cameras. One of them stepped behind me and my 12-year-old son and placed his hand on his gun for approximately 5 minutes. I'm sure due to trying to intimidate myself, my son, and my sister. We were there protesting. My brother had been murdered at the jail due to asphyxiation. And then they just told us lies. They weren't going to give us the video. We had to go out on our own, obtain it, not only from the casino that my brother was a guest at, and then the casino said my brother was trespassing. Meanwhile, he was comped a $500 a night suite. Washoe County shows up. Next thing you know, my brother's dead. There is no accountability in the whole state of Nevada. There is several police officers within Washoe County have killed 2 people each, unarmed, and out of those 4 deaths, all 4 were justified. That's just beyond me. It blows my mind. I don't know if any of you could actually believe that all 4 of those would be justified. Maybe out there it is where I'm from. That just would never happen. I appreciate your time. Have a great day.
Thank you for your public comment, Mr. Purdy. BPS, is there anyone else on the line for public comment?
Caller with the last 3 digits of 048. And that caller has hung up. We will try caller with the last 3 digits of 037. Caller with the last 3 digits of 037. And Chair, that caller has hung up as well. The open line is open and working. However, there are no further callers at this time.
Thank you so much, BPS. We'll go ahead and close public comment. Anything else from the members of the committee this morning before we adjourn? Get you all on one screen. Okay, all I see is attentive faces, but I don't see any hands up or any desire to speak at the moment. So let's talk about the rest of the week. Tomorrow, we're going to be doing 2 more competency-related bills. So we'll hear from Dr. Neighbors again. And again, tomorrow's a 9 a.m. start. So I heard rumors that there were a couple of folks who tried to log in around 7:55 today. Appreciate your diligence, but you don't have to do that tomorrow. Just jump on about 5 to 10 minutes before 9 o'clock and you should be fine. Friday, we have a meeting as well. That's going to start at 8 o'clock. I'll be presenting a couple of bills, and I have a suspicion those bills may take a little bit longer than the ones we're hearing today and tomorrow. And then committee, we are still working on what next week is going to look like. So I will probably have some more information for you about that at tomorrow's meeting. So stand by. Again, thank you, committee, for your questions and for your attention this morning. I hope everyone has a wonderful day. And until tomorrow morning at 9 o'clock, this meeting is adjourned.
Bye. Thank you, Chair.
Bye.